I was chatting to Dan earlier about a new defamation matter, but it reminded me of something. Um, and I know you like these tales from the bar, so just another one for you. This all started with a hospital pass. Actually, it was a friend's case, but he decided, oh, you like interesting, quirky defamation things, so I think you should take over this. So the claim arose. It was a publication in a foreign language newspaper, but that was distributed in London. And this was a pre-2013 case where England and Wales was seen to be very sort of claimant stroke plaintiff friendly. So people would sue here rather than other countries. Um, so the offending article, it had to be translated. So the solicitors had got the translation signed off on, and that's what we were sort of suing on the back on. However, the solicitors spectacularly had managed to lose the actual only copy of the actual newspaper that had this article in it. Now, there's a thing called the best evidence rule, which is you're always supposed to put the best evidence you can in. So if it's a document, you should put the original in. If you don't have the original, put the best photocopy. If you don't have the best photocopy, like some photograph you took on your phone years ago that shows the document in the background. That can be the same for sort of physical evidence as well. Ideally, here's the item that was actually used, or we don't have that. Here's an item identical to the one used. Well, couldn't find one of those. Here's an item similar to the one used for illustrative purposes only. So our solicitors have to go back, like cap in hand, to the defendant solicitors and say, "Oh, could we have another copy of the newspaper, please?" And they said, "Certainly, here you go." And the copy they sent us didn't have the offending article in it. And it was, our client was going, "It's just not in there. This is a different copy of the newspaper. It's the same newspaper, the right date on, but they've obviously just printed up one without that article in it and just stuck a different article in there." So we tried everything. We actually called the interpreter, the translator, and said, "Do you remember translating this article?" And it's like, "Yes." "So you remember the newspaper?" "Well, no, because they just photocopied the article, and I just had that." "Well, where's the photocopy?" It's like, "Oh, I sent it back with my witness statement with the translation." And it's like, "Can you remember?" Because there must have been a little bit of another article there. It's like, "Can you remember what the previous article was, or like the bottom 2 centimeters of text was on an unrelated article?" And it's like, "No, of course I don't. I do about like 20 translation jobs a day." And the judge just not having it. I mean, like I said, nowadays they do strike out claims like this on the grounds that, look, probably like 4 people actually read this, and you all know each other. Nobody cares anyway. It's what we call Jameel, after a case where it's even if you've actually got technically a legally arguable case with evidence and things, they just go. As they say, it's not just not worth the candle; it's not even worth the wick. So the judge just used that as an opportunity to strike out and basically drop big hints saying, "Be careful when when you've got like one key exhibit, maybe be a bit more careful with it." So there you go. Hope you found that vaguely, well, not useful or interesting, possibly even vaguely amusing. If you did, please consider clicking the like sign, well, all that sort of thing. Like I say, I'm not bothered about it, or I wasn't, but now I really am because I'm really leaning into my grifting.